Welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Robert E. Temmerman Jr., who I'm just going to call Bob. And Bob is an attorney. His office is here in San Jose. He specializes in estate planning, incapacity planning, and estate and trust administration. He's the managing partner and founder of Temmerman, Silly, and Coleman, LLP in San Jose. Bob received a BA in Economics and Political Science, magna cum laude from Boston College in 1975, and his JD, or law degree, magna cum laude from Santa Clara University in 1980. He's an active speaker in the estate planning community, including the Jerry Kasner Estate Planning Symposium, which is presented by Santa Clara University, estate planning councils, and bar associations, and has contributed chapters to books, including California Estate Planning, which is published by Continuing Education of the Bar. Bob has participated in writing the rules of the court of Santa Clara County Probate Court, and so he is one of the most knowledgeable people around when it comes to estate administration in our area here. On a personal note, Bob is quite an athlete. In 2009, he rode his bicycle 4,300 miles across the U.S. and Canada. In 2010, he rode his bicycle for 3 weeks throughout the mountains of British Columbia. He heli-skis every year and plays amateur hockey. So anyway, quite an active life. Congratulations on that, Bob. And so today, Bob and I are going to cover the topic, I'm a trustee, now what? Now, as we get started, I want to caution our viewers, we're talking about administering a trust after a death. Other considerations will apply for other scenarios, like for special needs trusts. Okay, so as far as the area of trust is concerned. And then another thing is that we want you to consult with an attorney when administering a trust. This is a huge topic. We're just going to cover some highlights. We're discussing administering trusts in California. Bob is a California attorney. I am a California CPA. The laws in other states may be different. So, Bob, let's get started. And thanks for joining me today.
It's always a pleasure, Mike. Thank you for having me.
Okay. Some people think that since they made a living trust, nothing special needs to be done at a death. Is that right?
That's a common misconception, Mike. Certainly having a living trust is advantageous. You've taken the time to plan your estate. The goal of having that trust was to maintain some privacy and to avoid court supervision in what would otherwise be required, a probate process. But just because you have a trust doesn't mean there is nothing to do in a post-death or post-incapacity context. There is a transition of control from whoever the trustee was to the successor trustee. That transition requires the successor trustee to gain access to the assets, gain control of those assets, and then to administer the trust according to its terms. Mm-hmm. The same process that we use in a will situation or in a probate occurs in a trust, but we do it without court supervision. A good example would be we'll still meet with the client a number of times to facilitate the administration and the eventual transfer after all notices have been given, all procedures have been followed, all accountings have been provided, and the beneficiaries have agreed to the distribution before that estate is ultimately completed.
Okay. Now, if the decedent had a living trust, does that automatically mean that no probate is required?
If the decedent had a trust and provided further, the decedent had funded his or her trust, meaning they have transferred their assets, their bank accounts, beneficiary designations under life insurance, their residence, things of that nature. If they fully funded their trust, then yes, no probate of their estate is required. But invariably, clients will leave certain assets out of their trust, either intentionally for convenience sake or unintentionally because they either forgot about it or they acquired the asset after the fact. In those situations, if the estate that otherwise would have to go through probate is under a certain statutory level, currently it's $100,000, soon to be $150,000 on January 1st of 2012, we can avoid probate on some of those assets that otherwise would have to be probated. We also have other options. If we can demonstrate that the decedent intended the asset to be in his trust, but for a mistake or an oversight, the courts, at least in Northern California, seem to be fairly generous in granting us orders called Hagstead orders that say, okay, we're going to give you an order that says those assets that otherwise would have to go through probate are in your trust, subject to the management and control of the successor trustee.
Great. Is it unusual for families to ignore or neglect the formalities of administering trusts after a death? Are there any consequences for that failure?
Is it unusual? I would say, in my experience, that most families don't ignore the fact that there's been a death and that there's something that has to be done, and they just don't know what it is. But occasionally, families will ignore it. In other words, the surviving spouse may still have access and control to assets and figures that it all belongs to me anyway, so there's nothing I need to do. In fact, that trust may have required a division into a variety of subtrusts. It may not have, but it may have, in which case ignoring the requirements of that trust can be devastating and expensive down the road when we eventually do have to administer that trust, sometimes many years after the fact, and create tax returns that go back many years after the fact. So hiding your head in the sand and pretending you're an ostrich or whatever and ignoring it is not an appropriate method for dealing with the death and administering the trust. It should be looked at in the terms that trust should be carried out.
Okay. What is community property, and why is that status important for trust administration?
My community property is property that's acquired by a husband and wife during marriage or by domestic partners during their domestic partner relationship. That's acquired by one's time, labor, effort, or skill. So typically that would be your wages, your compensation for whatever services were provided. That's time, labor, effort, and skill, and what you accumulate with that property. Now, the reason it's important is the husband or the wife or the registered domestic partner can only dispose of what he or she owns. And he or she may only own half of the community property. So I can't dispose of, for instance, in my case, my wife's half of the property. I can only dispose of my half of the property in the event of my death. So characterization of property, is it all of mine? That is, I inherited it, it's my separate property, and I kept it separate? Or is it property that we acquired during our extended marriage relationship, in which case it's community and I can only dispose of my community property? So characterizing those assets is critical in a post-death trust administration.
Okay. Are there significant legal fees for administering a trust? Does having a living trust really save legal or administration costs?
Are there significant fees? Mike, everything's relative. If you looked at the alternative, that if I didn't have a trust and I was involved in a probate process, those fees are set by the courts or by the statutes, and they're approved by courts, and they're a percentage of the estate. In most trust administrations, the legal fees that are charged are based upon what we did. How much time did it take us? I can say that through our experience, our costs and our charges are about 1/3, in some cases maybe as much as a half of what they would have been in a probate process. But because we don't have to file petitions with the court, we don't have to prepare those pleadings, we're just meeting with our trustee clients and giving them action items to carry out and following up with them periodically. That time is substantially reduced, and as a result, the fees for administering an estate under a trust is much less than it would be under a probate or under a will.
Okay, so I'm just want people to bear in mind there are still administration costs when you deal with a trust. You need professional help, and so those professionals earn those fees and deserve them. But there are some expenses that you need to expect, and maybe it would be an item that you should really discuss with the attorney as part of the estate planning process.
I always try to give an estimate to clients. What is this approximately going to cost? And it's a function of the number of different assets, the complexity of those assets, the functionality of the beneficiaries and heirs. The more dysfunctional the family, generally the more time we're going to have to expend in dealing with that. But on average, I think it's a fair statement to say it should be less than a probate. It should be about a third, maybe as much as a half. In a few occasional circumstances, it's going to be more.
Right. So, for example, if you have litigation, somebody's unhappy and the family is fighting, then
all bets are off.
All bets are off.
How much it can cost.
Okay. Now, should you keep a cash reserve for incidental items at death? And how can survivors get access to the cash?
I'm not sure I understand the question, Mike. Is the question, should a decedent prior to death have some cash or liquidity in his or her estate?
Yeah, I'm thinking of things like, you're going to need to pay funeral costs. I've seen situations where Social Security needed to be reimbursed maybe for that final payment for the month of death.
Let me suggest that it's not necessary. It certainly helps, but it's not necessary. In a situation where we're going to have some cash needs immediately following death, the last illness expenses, funeral expenses, things of that nature, there's no pre-burial policy that's been purchased or anything of that nature. An executor, if they have the ability, can front the money and then be reimbursed from the estate. If we need to get access quickly to accounts because the executor cannot advance the money or a family member can't do it, we can quickly get into court and obtain access to various accounts if necessary. In a trust administration, all I really need is a death certificate and a trustee certification in order to access an account within days of death. And typically we've done it in a day or two where the need was demonstrated.
Okay. Now, when we're talking about a trust now, what's the significance of a death certificate and the trustee certification? So you're sort of talking about these documents. Maybe we should.
So let me go to a trustee certification, because when a death occurs and a death certificate is generated by the county, generally the county health department, it's our indication that our settlor, the creator of the trust, is now deceased. And that creator was oftentimes the initial trustee. And so we have a transfer of power and control to a successor trustee. One of the documents that we will create for the benefit of our successor trustee client is what's called a certification of trust. And it's a statutory form, a form created under California law that, as long as it meets certain requirements, it certifies to the world that I'm the successor trustee, that my tax ID number is such and such, that this trust is either revocable or irrevocable, and that you should honor any directions that I, as the trustee, give. And that trustee certification, combined with the death certificate showing the death of the settlor, is typically all a financial institution will ever request. Because under our statute, the financial institution is held harmless for releasing the funds to a person who makes those sorts of representations to collect the assets.